This video helps you to prepare for a pre-trial conference at the Industrial Magistrates Court of Western Australia. It has been prepared by the court in collaboration with Circle Green Community Legal. A pre-trial conference is a meeting conducted by a clerk of the court to help the parties resolve their dispute and, if successful, avoids the need to go to a formal trial. The purpose of a pre-trial conference is to explore whether an agreement can be reached between the parties and not to decide who is right or wrong. Conferences are private and confidential, and no recording or transcript is produced. Conferences are also conducted on a without prejudice basis. This means the parties can discuss matters openly and freely, as what is discussed in the conference can't be relied upon by either party if the matter goes to a trial. In a conference, the parties have control over the outcome of the matter. If the matter goes to a trial, the court will decide the outcome in accordance with the law. If you are attending a conference, you should have already received a notice of listing giving you the date, time, and place. We also encourage you to check the hearing list the day before to confirm the details. You can do this on the court's website. Conferences may be held in person at the court's premises in the city, and they may also be held virtually by video conference or teleconference. You should clear your schedule, as a typical pre-trial conference can take around 2 hours. Before you attend your conference, make sure that you are prepared. You should be familiar with the facts and the arguments set out by both parties in the claim and the response. It's also a good idea to write out a statement that you can read during the conference. You don't need to repeat all the details in your claim or response, but you may wish to highlight facts or issues that are particularly important to you and to explain what you want to achieve in the conference. You should have thought about what outcomes you are prepared to settle for, including amounts of compensation, if appropriate. You should have prepared any relevant documents that you think might help the process, and you can bring these documents to the conference. A pre-trial conference is not a formal process, and there is no need for the formal presentation of evidence or the cross-examination of witnesses. However, important documents that are relevant to the dispute can be helpful for discussions. You should be dressed appropriately, in smart casual clothes, like what you might wear to a job interview. You should also be prepared to negotiate in good faith and to consider compromise to ensure that the conference is worthwhile and productive. If you have requirements, please let the court's registry know in plenty of time so they can make the necessary arrangements. For example, you may need disability access or an interpreter. If it will be difficult for both parties to be in the same room, you can make a request for a video conference or teleconference or other arrangements. If you make a request, you should provide good reasons, and remember that not all requests can be accommodated. Depending on the circumstances, you may be required to make a formal application to the court. If you're attending by video conference or teleconference, you should ensure that your phone or computer is working, that your battery is charged, and that you have a good internet connection. You should find a comfortable, quiet, and confidential space where you won't be interrupted, and you should be ready to dial in or be online using the link or invitation provided by the court at least 10 minutes before the scheduled start, in case of any technical issues. If you are attending in person, you will come to the court's premises in the city, which are located at 111 St George's Terrace. Please arrive at least 10 minutes early to ensure the conference starts on time. If you're driving, you should factor in the time it can take to find parking in the city. You can also access the court using public transport. When you enter the building, go to the lift and press for your floor, which is likely to be level 18. There are waiting areas if you arrive early, including confidential rooms if you need them. Please ensure you knock first, in case the room is already in use. The court has monitors that list the matters being heard that day, so you can confirm the correct time and room if you need to. You are able to enter the room 15 minutes before the scheduled start of the conference. Otherwise, you can stay in the waiting area and the registrar's associate will come and find you when the conference is ready to start. At this point, you may wish to ask the associate any procedural questions you have. Otherwise, when both parties are ready, the associate will bring the clerk of the court into the room. You should stand when the clerk of the court enters the room and sit when they sit. You should refer to the clerk of the court by their title. For example, Registrar or Deputy Registrar. The clerk of the court will begin by introducing themselves and explaining the purpose of the conference. They will then ask the claimant, the person who lodged the claim, to begin the conference process by outlining their position. In this example, we have the claimant, an employee, their support person, and the respondent employer's company director and industrial relations manager. If you are the claimant, you will start by describing what happened, explaining why you have a legal claim, and setting out what you want from the conference. It's best to have a prepared statement to make sure you make your argument well and to ensure you don't leave anything important out. After the claimant has stated their case, the respondent will have an opportunity to outline their position regarding their claim and explain their version of events. If you are the respondent, you can also explain any defence you say applies and set out what you want from the conference. It's important for each party to listen when the other is speaking. When you are presenting your position, you should stay calm and stick to the relevant facts. If the other party is saying something you don't agree with, you can make a note of why you disagree and bring this up when the other side has finished. If someone is interrupting you, ask politely for them to allow you to finish. After the parties have spoken, the clerk of the court will facilitate negotiations. It's common at this point to split the parties into separate rooms. The clerk will then help identify where there might be points of difference and points of agreement, explore options, and answer questions, including what happens next if the matter doesn't settle. It may be that either or both parties are asked what they are prepared to settle for, and to see if it's likely if there is enough common ground to come to an agreement. If the conference has been separated, the clerk may shuttle settlement offers between the rooms. It's important that you have considered settlement options before the conference. If you are negotiating over monetary compensation, you should have thought about the minimum you are prepared to accept to settle the matter. You can think broadly and creatively about what could be done to resolve the dispute, as parties are not limited to the outcomes that the industrial magistrate would be if the matter proceeds to a final trial. Remember that a settlement involves compromise, and it's very rare that either party is 100% happy with the outcome. You shouldn't be concerned with winning or losing your matter. Your main consideration should be a settlement outcome that you can live with, and that is preferable to a formal hearing, which can be time-consuming and stressful. Towards the end of the conference, the parties will be brought together again, and the clerk of the court will summarise the outcome. If an agreement has been reached, the clerk will make sure that both parties are clear about the terms of the agreement. If no agreement can be reached, the clerk will explain the next steps of the process and issue programming orders as necessary. In the event of a settlement, it's normal for a written agreement to be made and signed by both parties. It is usual for the parties to be responsible for drafting the agreement, although occasionally the clerk of the court will assist the parties with drafting consent orders in the agreed terms. To avoid further dispute, it's very important to be clear in the conference about the terms that are important to you. Some key considerations are: what will each party do and when? What is the scope of the settlement? Does the agreement settle just the matters in dispute or all potential future claims? If money will be paid, is the amount before tax or after tax? If another action has been agreed to, does it need to be done in a specific way? In a written agreement, certain terms are considered to be fairly standard. These include confidentiality and non-disparagement clauses, which means that both parties won't discuss the issues or speak negatively about each other, a time for payment, and an expectation that the claim will be discontinued after payment is made. Some agreements also have an indemnity clause, which means that a party that breaks the agreement will have to pay the legal fees of the other side. Most agreements are also reciprocal, which means that these common clauses apply equally to both parties. If you don't want any of these typical terms in the agreement, it's important that you raise this because it's often assumed that they will be included. Sometimes a settlement can't be reached within the conference. If an agreement can't be made, the claimant may choose to discontinue the claim and end the matter, or to continue to a formal trial. A trial involves both parties making written submissions and providing evidence, then arguing their matters in a formal court environment. At a hearing, both parties must argue their respective cases, and they may be cross-examined as witnesses. The industrial magistrate will then make a binding decision. This video has outlined a typical process for a pretrial conference, but please be aware that your own conference and claim process may be slightly different. We hope that this video has been useful, but if you need further information, you can read the resources on the website of the Industrial Magistrates Court and on the website of Circle Green Community Legal. We wish you all the best with your matter.